Hello, welcome. This is Roger Royce, host of the 10,000 Startups podcast and also a partner with Haynes Boone Emerging Growth and Venture Capital in our Palo Alto office. And today our topic is going to be CFIUS. Now, you may not have heard of CFIUS, but you probably have if you've done anything in the law at all. It seems to pop up everywhere these days whenever there's a foreign investor or foreign money coming into a company. And today we have two lawyers who spend quite a bit of their practice working on these issues. Ed Lebow has been representing clients in international trade cases for more than 30 years. He is AV peer review rated Preeminent by Martindale-Hubbell Law Directory. And he's in, I think you're in our Washington, D.C. office, aren't you, Ed?
That's correct.
Yeah, and then Colin Cox is an associate in our international practice group. He's licensed to practice in both Florida and Texas. He focuses on international corporate matters and cross-border projects. So thanks for being here, guys, to talk to us about CFIUS. So
Thanks
first
for having
question for you is, what the heck is CFIUS? What does it mean? What does it stand for? Who has to worry about this?
All right, well, let's start with some background. CFIUS is the Committee on Foreign Investment in the United States. And it is exactly what the name sounds. It's a committee. It's an inter-agency group with people from 8 different government agencies. It's headquartered out of the Treasury Department, but there are people from Commerce, Defense, Energy, Homeland Security, Justice, State, USTR, Science and Technology Policy, others on an ad hoc basis. CFIUS is authorized by the U.S. government to review and impose conditions on or block certain foreign investments by foreign persons in the United States. So where did this all come from? Let me give you a little history. CFIUS was established by executive order in 1975. And then you begin to hear more about it in the 1980s when there was nervousness about the Japanese investment in U.S. technology. And then again in the aughts where there was concern about Arab investment in U.S. natural resources or near ports and so forth. But the real surge in interest in CFIUS came in 2018 when Congress passed something called the Foreign Investment Risk Review Modernization Act, only a title Washington could come up with, called FIRMA for short. And the interesting thing about FIRMA is that it is one of the few pieces of legislation that passed with strong bipartisan backing during the Trump administration, because it's aimed at foreign investment in U.S. technology startups, places where there wasn't a sufficient ownership share to give CFIUS jurisdiction under the old law, so that the jurisdictional limits were greatly reduced and the number of subjects was greatly expanded, with the idea that the U.S. would pay a lot of attention, particularly to Chinese investment in startup and new technology U.S. businesses. It's not written to be anti-Chinese per se, but in many ways that's the effect of it. So that
Can I ask you about that, Ed? I mean,
Sure.
we think of CFIUS, we always think China. Does this only apply to Chinese investment in U.S. companies, or could it be any country?
Absolutely not. It applies to any foreign investment where there is an ownership interest granted over a U.S. business or assets that have national security implications. And in fact, as Colin will show you some statistics later on, with a good deal of sort of self-policing by the Chinese of late, the majority of cases are not against China at all. And in fact, we've worked on a couple of significant cases in the last year involving Luxembourg, Germany, Japan. A lot of different foreign investment sources are covered. And conversely, not all Chinese investment is banned. And we've spent a good deal of time showing Chinese investors how, if they're making passive investments or trying to earn money but not gain access to the latest U.S. technology, there's plenty of welcome for them in the U.S. market.
Okay, thanks. Okay, so I sort of understand now. You said something about, oh, well, here it is, covered transactions, covered investment, and in particular, critical technology. So what does that mean? Who, in other words, who should have to be worried about this?
Okay. Well, there are certain kinds of CFIUS filings which are now mandatory. And one of the places where it's mandatory is where there's a foreign government investor. And another is where there is investment in something called critical technology. And critical technology is basically technology that requires an export license to the country of the investor, or a certain kind of export license. So that the most advanced US technologies are critical technologies, and they are subject to mandatory CFIUS filings. Now, there are also other kinds of situations where CFIUS filings are, if not mandatory, they're optional and usually wise, because CFIUS has jurisdiction. And if CFIUS wants, it can come in later on and look at the transaction and even impose conditions or unwind it. And one of those is an area with this critical infrastructure in the United States, large interstate pipelines, power plants, control systems, and so forth. And another is where there's sensitive personal data of US persons. And we can look at that a little bit more closely later on. But critical technology is the one that is the most sensitive, the most obvious these days, and where CFIUS pays a lot of attention, and that's defense articles, nuclear articles, agents or toxins, or items that are subject to export controls.
If we could stop, we could pause for a second. Let me double click. I think I saw on an earlier slide that this doesn't even have to be a controlling investment. It could be just a minority passive investment. And if it's a critical technology.
Exactly right. Exactly right. That's one of the things FIRMA did. It no longer, you don't even have to have control. And what CFIUS used to call control was 10%, which was pretty low. But you don't even have to have that level of investment in order for CFIUS to have jurisdiction if you're dealing with one of these TID US businesses with critical technology, with critical infrastructure, or with sensitive personal data.
Okay, and if it's not a critical technology, it looks like it could still be subject to CFIUS if there was some sort of managerial control. Is that what covered transaction means?
Yeah, but that's generally what it means. That CFIUS has jurisdiction even when the filing isn't mandatory. Yeah. Okay. If there are certain levels, if that 10% gets you a seat on the board, certain observer rights and so forth, you can be subject to CFIUS. Yeah.
Yeah, that's exactly where I was going, because oftentimes you get a small investment that comes in, but then you get a board seat and, or something else, some other managerial rights.
Right, okay. Right.
So you're about to tell us which technologies we have to worry about. And I'm going to be very interested in what you say about data.
Okay, well, I'm not going to read this whole long list. I have it on the screen. For those who aren't looking, I suppose I could give a quick summary. You're looking at biotechnology, artificial intelligence, certain kinds of navigation and microprocessors, hypersonics, a whole long list of emerging technologies. And for critical infrastructure, again, as I mentioned, you're looking at chemical production, dams, industrial base, nuclear reactors, and so forth.
That is a broad list. That's a big
long list. There's no sense reading it now, but if you have any question, you really should check with us or with someone else who is following the CFIUS regulations.
The food and agriculture kind of jumps out at me, because you wonder, that's one that you see a lot of companies coming in here with, new food and agriculture type.
Right. There's concern about supply lines being controlled by foreign persons who could somehow disrupt them, though it's a lot harder to move the fields out of the country than it is some other things. So,
information technology is another one.
Right. You remember a few years ago, Chinese company bought and successfully cleared CFIUS Smithfield, the pork producer. And I think that may be one reason why there's been increased sort of attention to food and agriculture, because that was such a high visibility deal.
Yeah.
But let me, before Colin comes and tells you a little bit about the process, let me just tell you a little bit more about personal data.
Okay.
Another worry is that foreign companies could get access to personally identifiable data of US persons. Their social security numbers, their medical conditions, their sexual preferences. So they might be blackmailable or people with medical conditions. And in fact, just it may seem humorous, but a few years ago, CFIUS blocked the acquisition by a Chinese company of the website Grinder because it catered to a gay audience, and there was some concern that Chinese might use information about people who haven't come out yet to blackmail them in some way. But it's not all companies that have personal data. It's only those that have sensitive populations, such as U.S. government employees. But if it's to the general public, you have to have data on like 1 million individuals. So it's got to be a company that has a pretty large data set. So it's not everyone, but it's something you have to think about. And again, here's a list of some of the sensitive categories: financial data, physical and mental health, biometric data, data used to apply for security clearances, a number of other things. And again, if you're involved in a company that has this kind of data and you have foreign investors, you got to think twice before you go forward without CFIUS clearance. And the final area I just wanted to mention where the CFIUS jurisdiction is real estate, which is located within proximity, like usually it's a mile of a whole long list of U.S. military bases, but there are exceptions for certain, urban areas, for example. So not everything in Boston, which is within a mile of the Boston Naval Base, requires CFIUS clearance. Out west, where there are missile sites and test ranges and so forth, sometimes the limit is extended to as much as 100 miles. So that investments that are within 100 miles of a certain more limited set of military targets is also subject to CFIUS review.
Wow.
Anyway,
even real estate can be subject to
even real estate. So look, let's let Colin step in here and tell us a little bit about the two different kinds of CFIUS filings and how companies have got to decide between the two.
Sure. Thanks, Ed. So there's two different ways that a company or two companies, the U.S. company, the U.S. target, and the foreign acquirer, the foreign investor, can submit their CFIUS filing to Treasury. There's a long form and a short form. Now, the short form is called a declaration, and it requires significantly less information. And because of that, the processing time normally takes it takes a shorter amount of time, anywhere between 6 and 8 weeks. By law, the declaration form has to be reviewed by CFIUS within 30 days. And there's often, with both the short and the long form, there's a Q&A process after you submit you go back with CFIUS. They'll often have questions to the parties. You have to answer them. And with the short form declaration, you have a shorter amount of time to answer those. So that's the short form, the declaration, 6 to 8 weeks, and CFIUS has to review it, give you a response within 30 days. The longer form is called a notice, and this takes significantly longer. So if you have two parties that are anticipating a notice, normally we'll help them organize and plan around this time period, because it can take anywhere between 3 to 5 months. Now, the notice, it's a longer form, more detailed, requires certain personal information about the officers and directors of the foreign acquirer or the foreign investor. But what's interesting about this process is that you have the option to do kind of like a draft. You can submit a pre-filing to CFIUS. They'll review it, they'll give you feedback, and normally that takes about 2 weeks to get that feedback from CFIUS, and then you can make changes to the filing before you submit the official version, the formal filing, to CFIUS. So this notice, the longer filing, the timeline from when you submit after, if you decide to do a draft, is divided into kind of 2 periods. You have first a 45-day period for the review, and most cases tended to close in this period. But if it's a little bit more complicated, or if CFIUS is just backlogged, it'll get bumped into the second period called an investigation. And we normally see everything close. If it doesn't close in that first 45 review period, they tend to close in the second 45 days, sometime in that second investigation period. In rare cases, that second 45-day period can get extended by an additional 15 days. And then in even rarer cases, there's an additional 15-day period for presidential review. But just like the shorter
let
form,
me
the
jump in.
declaration.
So generally, I guess I could expect if this filing is required, it's going to delay my deal by about 45 days and maybe 3 months. Is that right?
Well, it has a potential to be a 3 to 5 day process. But what we would potentially say is that rather than delay your deal, hopefully we're involved or someone is involved beforehand to help you structure your deal around this, so that you're not having to delay your closing or delay the transaction a significant amount of time. Normally, and Ed and I we'll talk about this in a little bit, is how you plan your transaction around the CFIUS filing. And we like to get in beforehand to help the parties understand what the risks are, what the timelines are, what the process is, so that we can help plan the transaction. And really what the parties should be doing is planning their closing around the CFIUS timeline.
Gotcha.
But I would say, Roger, that you do need more time, because if you do a declaration, you hope that you get it in right after the parties sign the stock purchase agreement, for example, and that CFIUS starts the clock within a few days, and you hear back within 30. So maybe within a month or 6 weeks, you've got your clearance. But what has happened with CFIUS lately is that they're quite busy, and they've taken maybe at least 20% and maybe more of their declaration filings, and they've gone back to the parties and say, sorry, we can't finish or do this, or this is more complicated. We can't do this within the declaration period. Please file a notice. So you lose all the time you've just put in on the declaration, and then you're stuck with the notice period. So many companies that have complicated deals just to say, okay, we'll just go with the notice the first time. We won't take a chance of getting bounced. That way we can plan around it. But then when you go with the notice, you've got the 2-week pre-filing period, you've got the 45 days CFIUS to look at it. They may want a little bit longer. So you have to if you want to make the CFIUS clearance a condition of closing, you're really looking at closing from 3 months to as much as 5 months after the signing of the stock purchase agreement. So, you try to be prepared, you try to have the issues covered ahead of time, but this really can be a delay in the overall process.
Got you. Okay.
Yeah. And in addition to a delay, the one other thing with the notice that the parties will want to anticipate is that there is a filing fee. And so whereas the declaration you don't have to pay, with the notice you do. And that filing fee is determined based off of the value of the transaction.
Yeah, so for our podcasters, I'm looking at these fee amounts, and they can get up to $300,000 for a big deal, right? But nothing up to so let's say 500,000, 499,000. Then for 500,000 to 5 million, it's $750. 5 million to 50 million, $7,500. 50 million to 250 million is $75,000. So it's that, boy, that fee ramps up pretty quickly, doesn't it?
It does. And there's no fee for a declaration, interestingly, which is an incentive to go with the declaration, but then you can still find yourself bounced back to the notice if they don't complete it in time.
I see. Okay.
So anyway, Roger, one of the things we try to do is help foreign investors make investments in the United States without having to be enmeshed in CFIUS. And you can't hide it. You can't not report it if you have to. If you have a complicated case, you're wise to report it, because they're increasing the penalties now from 250,000 to 5 million. So they really want people to be reporting. But if you have a passive foreign investor who's a limited partner with limited rights in a fund that has a U.S. general partner, and the U.S. general partner is not subject to control or replacement or so forth by the foreign limited partners, you can set the fund up so it has foreign investors, but it's not a foreign person for CFIUS purposes. And that's something we like to try to help people do if it's at all possible.
Yeah, that's a big issue. Certainly here in Silicon Valley where I am, because most investment funds, venture funds I see, they have foreign investors. Because that's how, foreigners access our startup market here. And we always have to worry about this. And just kind of have to run the gauntlet and make sure we're not going to have it. Because that's the last thing in the world a fund wants, is to have a CFIUS compliance problem. That's the second to last thing. The last thing would get one of those big penalties you just mentioned for getting it wrong. Okay. So so I have to ask you, are there ways to structure around this, or do we just have to comply?
Well, I think I've just told you the way to structure around it, which is to to have a fund with a US GP and the foreigners don't have control. But otherwise, there's no way really to structure around it. One of the issues that often comes up in that regard is if you have a client who's a seller, a U.S. company that wants to cash in, it's gotten to the point where it can go public, or at least sell interest to other parties. If they have an auction process, they can look at who's bidding, and sometimes the foreign person will be less attractive because they carry with them a CFIUS burden or CFIUS reporting burden. It makes it harder for foreign investors to buy into U.S. companies, and it makes it harder for U.S. companies to access the full international market for their company if they decide that they want to seek additional funding.
Yeah. So suppose we're in an M&A scenario or context, and boy, we don't like this CFIUS stuff. Maybe we won't get it approved. So the company says, well, how about what if we sell them we just sell them pieces of assets? We just transfer technologies. Are there rules that would apply to those tech transfers?
Sure, there are export controls on the tech transfer.
So we kind of end up in the same place then, don't we?
Well, if not in the same place, a very similar place. And also, even if you're not selling the whole business, if you're selling significant assets, so it provides control over those assets, CFIUS can look at that and say, what you're really trying to do is sell the business by another name. And they can come down pretty hard on you if they think you're being duplicitous.
Oh, really? Okay, I want to circle back and double click on one other issue. It's about the data, because it seems, every company now is, especially in the age of artificial intelligence, is either a data company or a data enabled. So tell me, when is data going to be one of these critical technologies that might give us some problems?
Well, data in and of itself isn't a critical technology. The software to manipulate the data or to gain access to the data might be critical technology if the software requires export license, to the country of the exporter. But if the data is in any one of these listed categories, these are right out of the CFIUS regulations, then, and maybe I should read them because we have people who aren't looking at the screen here, then you might have an issue with CFIUS, and that's financial data that can be used to determine a person's financial hardships, data in a consumer report, data in insurance applications such as health insurance applications, data relating to physical, mental, or psychological health, non-public communications, emails, for example, geolocation data, biometric enrollment data, data used to generate ID cards, government data related to government security clearances, data containing the application for employment in a position of public trust, or genetic data. But as I mentioned, other than for data from sensitive groups such as government employees, you have to have 1 million data sets in order for CFIUS to apply for all of these categories, except for genetic data, where there's no 1 million person requirement.
Okay, got you. Okay, well, is there anything else that our company should know about CFIUS? I mean, I think you've sort of convinced me that we need to be on the lookout for almost any company, any tech company that I work with anyway, that's taking they're taking a foreign investment, taking in a foreign investor or selling to a foreigner. Any other major points about CFIUS that you'd like to leave us with?
Only the interrelationship between taking in foreign investment and sharing data with foreign persons. Because often when you're looking at selling your company or taking an investment, you might be sharing information about the company and giving people a hint or a taste of what your valuable technical assets are. You have to be careful that you're not engaging in a deemed export where you're showing a person who's not a US person data which itself or technology which requires an export license. So you have to be careful dealing with technology and foreign persons.
You know, that last point is really subtle and super important. The deemed export idea, that just by providing information to somebody overseas, you actually might be exporting critical technology, right?
Sure, absolutely. And again, we've had unusual circumstances where a foreign company develops abroad technology, sets up a subsidiary in the United States. The US sub works with the technology. It's therefore in technology in the United States, subject to US export controls. Then employees of the company go back and they talk to the management of the professor or whatever back in the home country. That's a deemed export. And people got in trouble for doing that. So you have to be very careful sharing technology with foreign persons.
Yeah. Well, that's the interesting thing about what you guys do, Ed and Colin, with international trade. It seems these issues just pop up everywhere. You know, we just have to be super careful about it. Well, okay, I want to thank you for being here. This is Roger Royce with the 10,000 Startups podcast. We've been talking with Ed Lebow and Colin Cox about CFIUS and international tech transfer issues and international investment. So thanks again, and we will see you all next week.
Thank you, Roger.